Honourable Senators, I rise today to speak to Bill C-76, legislation that will alter the rules around the most basic fundamental exercise of our democratic rights in Canada. That is, of course, our right to vote. As parliamentarians, it is our responsibility to safeguard that right to vote and to protect the security of our precious Canadian system of free, fair and democratic elections. This matter should concern us all, particularly in the current global political climate. Many countries in the world are consumed with issues of electoral security, with allegations of foreign influence and interference in domestic elections a preoccupation for many. Shifting global powers and the advent of new technologies have created increased opportunity for manipulation of democratic voting systems. As noted political commentator and journalist David Frum stated when he testified before our Senate Legal and Constitutional Affairs Committee, quote, "One of the features of the 21st century politics as opposed to 20th century politics is that authoritarian governments are more careful about the use of violence than they used to be, but they have greater powers and surveillance and interference than they have ever had before. A hostile foreign power is less likely to come at you with rockets and tanks, but more likely to come at you with these new means and try to shape your government. The point of war is to change the will of the antagonist opposite. What if you can change the will without the expense and risk of war by operating directly on the voting system of that country? That is a very significant challenge," quote. At the same time as major nations in the world are consumed by this issue, this Trudeau government brings forward election legislation that blows the door wide open for foreign interference in Canada's elections. As we have seen so often from this Liberal government, they talk a good game, but then only introduce half measures that fail to close the loopholes for foreign interference and the influence of third-party spending in our democratic process. Why do they drag their feet on this matter when such fundamental democratic rights and even national security are at stake? Will they sacrifice those principles in order to create an outcome that would be the most advantageous to them? Far be it from me to be cynical, Honourable Senators, but the Trudeau government has once again failed to provide satisfactory answer to these important questions. Instead, they delayed introducing legislation and now are anxiously pressing to get this legislation passed quickly before the next election. Our Senate Legal Committee was only able to have 3 meetings on Bill C-76, an almost 300-page bill. And yet the Trudeau government is ploughing ahead with this legislation at all costs. The matter of extending voting rights to citizens living abroad is currently before the Supreme Court in a case entitled Orr v. Frank. The Ontario Court of Appeal sided with existing election law, establishing that current limits on expatriate electors living outside of Canada for less than 5 years and having an intent to return are appropriate. However, the matter of extending voting rights to more citizens abroad is currently before the Supreme Court of Canada, which is due to report soon. Oddly, the Trudeau government has instead insisted on this legislation passing before that Supreme Court judgment is rendered. While it is never wise to prejudge the outcome of the Supreme Court's deliberations, it is not commonplace for the Supreme Court to overturn decisions rendered by the Ontario Court of Appeal. In any case, it would not be prudent for the Trudeau government to rely on the court doing so. Make no mistake, this bill is deeply flawed. It leaves gaping holes in our electoral system, dramatically diminishing identification and verification requirements and opening loopholes to allow third parties and foreign entities to influence the outcome of our elections. Even the Minister of Democratic Institutions has indicated that it would be virtually impossible to prevent foreign interference during the 2019 election. At the same time that the Trudeau government is loosening the identity verification provisions of the Elections Act, it is also extending voting rights to more Canadian citizens living abroad. This combination leaves our democratic electoral system vulnerable to manipulation and abuse. Currently, the Elections Act stipulates that a Canadian elector not residing in Canada can only register to vote in a Canadian election if he or she has been living outside of Canada for less than 5 years and has an intention to return to Canada. In other words, a short-term non-resident Canadian. However, Bill C-76 would remove these limits so any Canadian citizen living abroad, even a long-term non-resident who has lived outside Canada for 25 or 30 years, or maybe almost his or her whole life, will be eligible to vote in the next Canadian election. Furthermore, while Canadian electors must have resided in Canada at some point in their life, there is no minimum length of Canadian residency required in order to qualify for the vote. That a non-resident Canadian living abroad with no ties to Canada, who may have lived in Canada only for a month decades ago, can vote in our federal election to determine the political fate of our nation seems absurd. Even the Attorney General of Canada has argued before the courts that a link to residence in Canada is vitally important in Canada's electoral system, which is based on local constituencies. The residence requirement is a way of ensuring that a Canadian citizen is part of the social contract between a democratic government and electors. The electors choose a local representative who serves their community and makes laws regarding matters that affect the electors' day-to-day lives in their area. If an expatriate Canadian has only lived in Canada for 1 month in his or her whole life, or if he or she has lived outside of Canada for an extended period of time, it seems unreasonable that that citizen should be able to influence local electoral outcomes in a distant region. Why should they have a say in choosing the lawmaker whose laws they are not beholden to follow? An estimated 11,000 non-resident electors voted in the 2015 election. Roughly 2 million Canadians live abroad. If Bill C-76 passes into law as is, the potential pool of expatriate voters will increase significantly. That could make a profound difference in our Canadian elections, honourable senators, when really only a small number of votes nationwide can determine which party forms the government and how sizable that government will be. In 2015, for example, less than 15,000 votes made the difference between the Liberals winning a minority or a majority government. In the 2015 election, the foreign organization Lead Now heavily targeted the Saskatchewan riding of Regina Louvain. The NDP candidate won by a razor-thin margin of about 100 votes. With 24 votes, we've recently discovered, cast by non-resident Canadians for that constituency, you can see the potential for non-resident votes to influence close election outcomes can be significant. The process for non-resident Canadians to register to vote is vulnerable to abuse. In order to register to vote, an expatriate Canadian simply needs to fill out a simple form indicating his or her last residential address in Canada, which determines in which constituency their vote will be counted. No proof of that residence is required, and Elections Canada doesn't verify it unless a specific complaint has been lodged. The potential elector applies online and presses a button, which submits an attestation which doesn't even outline the significant penalties for fraudulent voting. The elector is then registered and receives a mail-in ballot to vote, all without ever having to meet or even speak to an elections official and without any kind of verification. This is especially concerning because of the opportunity it provides for foreign interference in Canadian elections. Unfortunately, Bill C-76 doesn't establish adequate safeguards in this respect. Given the current prominence of the issue of foreign interference during elections in the United States, Canada must be ever vigilant against allowing anything similar to occur within our borders. Unfortunately, our government and elections officials are remarkably blasé about the matter. Recently, Prime Minister Trudeau was asked how much Russian interference occurred in the last Canadian election. His response? Not much. My Conservative colleague MP Blaine Calkins submitted an order paper question in the House of Commons asking for details on Prime Minister Trudeau's comments. Of course, now the PM won't answer, citing it as a matter of national security. And yet, when we questioned the Chief Electoral Officer about this at Legal Committee, he informed us that he had absolutely no knowledge of the Russian interference the Prime Minister had confirmed. As a very wise colleague of mine pointed out, it is unbelievable that the Canadian Chief Electoral Officer, the person in charge of keeping our electoral system safe and secure, is so remarkably incurious about information concerning our national electoral security. An insecure electoral system under this legislation is especially concerning for Canadian electors living abroad under repressive or coercive regimes. As David Frum testified before our Senate Legal Committee, quote, "As you study this bill, I invite you to consider some other realities. Suppose, instead of the free and democratic United States, an expatriate like me lived in another country, a country that was not a democracy and not free, a country that surveilled and policed every aspect of my behavior according to a system of social credit, as it calls it. A country that noticed when I received a ballot to vote in an external country's election and possessed both the technology and the will to inspect how I cast that ballot. A country that did not believe in free elections or privacy rights. A country in which the state could and regularly did determine the success or failure of my business and professional life, or my ability to borrow money, rent an apartment, or buy an airline ticket, varied or could be denied altogether according to political reliability. A state with a strong national interest in shaping the politics and governance of other countries, Canada very much among them. a state with the military and economic power to ignore protests and remonstrances from the Government of Canada, indeed to frighten the Government of Canada into considering carefully whether it dared issue such protests and remonstrances. He went on to say, quote, "Given the inevitable defects of ballot security outside of Canada, which is a problem whether people are short-term or long-term expatriates, with short terms, you are dealing with a relatively small number of ballots that are probably not outcome-altering. But if you expand the population from the current few tens of thousands to hundreds of thousands or millions of ballots being cast outside of Canada, many being cast not in the US or Britain but in other countries, you create an opportunity for governments that have very focused foreign policies interested in affecting other countries, Canada very much on that list, to use pressure on voters, maybe even fraud on the ballots. Your security measures will never keep pace with the interventions that foreign governments can imagine and can create. You will be creating opportunity for those governments to use Canadian elections as an opportunity to shape the Canadian governments they deal with," quote. Mr. Frum's concern with Bill C-76, a concern I share, is that with this law, we could essentially be handing a stack of ballots to foreign governments to infiltrate Canadian elections. Excuse me. Unless you think Canadians living around the world aren't numerous enough to have that kind of an impact, I would encourage you to reflect upon the fact that an estimated 300,000 Canadian citizens live in Hong Kong alone. Besides the foreign interference implications, another serious concern with Bill C-76 is its failure to eliminate spending abuses by third parties. When the Chief Electoral Officer appeared before Senate Legal Committee, I asked him about a certain scenario. If a Canadian citizen, perhaps a multi-millionaire celebrity rock star who has lived in the United States for more than a decade, decides to host a benefit rock concert and anti-pipeline rally at Madison Square Garden to raise money and anti-pipeline fervor, an event which would be designed to motivate non-resident Canadians to vote against one particular party. According to the Chief Electoral Officer, such an event would be allowed without partisan activity restrictions under this flawed Bill C-76. Similarly, the CEO confirmed that a foreign government could take a full-page newspaper ad out or air a television commercial advocating that Canadians vote for or against a candidate or party. And that advertisement by a foreign government, think Russia, China, Iran, would not be subject to any restrictions under Canadian law. Another stunning matter I discovered during our legal committee's study of this legislation was how the Trudeau government has removed all actual independence as between the Chief Electoral Officer and the Elections Commissioner. The Commissioner's office was previously housed with the Department of Public Prosecutions, given his role as the primary enforcement officer regarding elections infractions. Bill C-76 will move the Elections Commissioner and his office back under the Chief Electoral Officer's control. In a worst-case scenario, what if the Elections Canada Chief Electoral Officer committed serious election offences under this Act? The Elections Canada Commissioner would be in the completely untenable position of investigating, prosecuting, deciding not to compel, and penalizing his own boss. When I asked Democratic Institutions Minister Karina Gould about this alarming situation, perhaps unsurprisingly, she was unconcerned. Honourable Senators, Bill C-76 will refashion the Commissioner of Elections Canada as a subservient employee of the Chief Electoral Officer. Under the provisions of this bill, the Chief Electoral Officer hires, fires, and determines the remuneration of the Elections Commissioner. The Chief Electoral Officer also establishes the boundaries of the Elections Commissioner's good behaviour and determines the location of his office. If that's not an employee-employer relationship, I don't know what it is. It might be a lot of things, but it certainly isn't independence. As I said at the Legal Committee, it seems this Trudeau government needs a definition of independence that bears some actual resemblance to the actual definition of independence. Honourable Senators, we see news stories on a daily basis from almost every news outlet about possible Russian foreign interference in the last US election. Maybe when you watch all that news coverage, you wonder, could that happen here in Canada? It did happen here in the last federal election. Prime Minister Trudeau admitted it. Yet despite this, his government provides us with woefully inadequate safeguards against foreign interference in Bill C-76. They could have slammed the door shut, but instead they've left it wide open. While the Trudeau government opens Canadian elections to a pool of 2 million additional voters with potentially little or no connection to Canada, Canadian policies, or current events, I cannot help but think that it really creates a perfect storm. It used to be difficult to mobilize 2,000 expatriates around any given issue. Now, in the age of widespread social media, that task is far less onerous. At the same time, though, you have a voter base whose identity...
Sorry to interrupt you, Senator Batters, but your time has expired. Are you asking for 5 more minutes?
You need 2 minutes.
Is leave granted, honourable senators? Is leave granted, honourable senators? Agreed. Senator Batters.
Thank you. At the same time, though, you have a voter base whose identity is hard to regulate and verified, masked by the anonymity of the internet, with access to 2 million Canadian ballots to determine the outcome of the next Canadian election. Surely we can compromise, Senators, to limit that potential pool of voters by restricting it to those expatriates who have resided in Canada for at least 5 years, those that we would assume possess a deeper connection to Canada and our democratic electoral system. Therefore, honourable Senators, in amendment I move that Bill C-76 be not now read a third time, but that it be amended in Clause 152 on page 80 by replacing line 28 with the following. Quote, the application resided in Canada for a total of at least 5 years, quote. I ask for your support for this common sense amendment. Thank you.